As a quick review on what this is all about and what is at play, there are so many rings to this circus, it's hard to keep up. Here's what we have at this moment, and I'm probably forgetting some things. First, we have the federal sentencing that we're awaiting. This is going to go well into next year, according to federal sources. If you'll remember from the sentencing documents, there's going to be some extensive interviews that Alex has to give to tell all of the information that he knows in these cases. Why is this important, the federal sentencing? Remember, this is one of the goals, to get Alex into federal prison instead of state. Which brings us to number 2, the state financial crime trials are looming. The first one is scheduled this month in just a few weeks. Defense has done their best to delay this because 3 guilty verdicts in these types of crimes is a life sentence in state prison. Thus the delay, because if they can get a federal sentence first, he can serve that time in federal prison, should he somehow manage to get out of his murder charge either through appeal or through a new trial. Defense is pushing for a new trial on the murder charges and playing every card they possibly can. Defense has claimed that Judge Newman committed judicial misconduct, while at the same time not claiming that Judge Newman committed judicial misconduct. And that's what brings us to this extraordinary writ of prohibition that we're talking about today. They claim Judge Newman is a material witness regarding the Becky Hill manor. I say they were present for the hearings about the juror that are in question as well, and therefore they're material witnesses themselves by their own logic. 6. They want Judge Newman off all cases to deal with Alex Murdaugh. I take issue with that. I do think that maybe letting someone else handle the evidentiary hearing about Becky is not a bad idea, just to move things forward. Taking himself off everything else, though, feels like an admission to misconduct, and it would be sickening to see that happen at the end of an unblemished career like his. 7. Defense skipped a step by going to the Supreme Court, and the Supreme Court may tell them so. They were supposed to file motions first in circuit court, but they simply wrote a letter to Judge Newman. They're saying Judge Newman committed judicial misconduct by speaking at his alma mater and briefly on the Today Show. I say they haven't considered the canons they quote in their entirety, as speaking at scholarly presentations are excluded, which is what he did at his law school. In both cases, he was being interviewed about his life, not just the Murdaugh trial. Of course, the Murdaugh trial came up, but did he venture beyond what's allowed by these canons with his brief answers to people's questions? This is what needs to be considered. What also needs to be considered is, did he commit judicial misconduct or not? If you say no, your whole writ is moot. If you say yes, it would lead to a whole mess of looking into Judge Newman and cases he's judged. I want to also mention that them wanting a new trial makes sense because an appeal is heard by judges, not a jury, and I believe that they feel they stand a better chance with a jury than appeal judges. As I said earlier, personally, I think stepping aside for the evidentiary hearing is not a bad idea, but asking Judge Newman to step aside from all things Murdaugh is just unfounded, and I don't believe they've proved their case that this should happen. And finally, this writ was filed on November 1st, meaning a reply is required by the 10th, so we should be hearing something soon. So that sums up the review. Let's get on with part 2. This is Legal Updates with Cassidy O'Connell. Clutch your pearls. A judge said a guilty man is guilty. Team Alex files a writ of prohibition to stop Judge Newman from hearing the case. Part 2. Welcome. Picking up where we left off, the next accusation comes from Judge Newman's appearance on the Today Show. That transcript is Exhibit C, and the claim is that he expressed his, they say persona, I think they mean personal, opinions about Alex's guilt. But what did Judge Newman say here? Let's watch clips of what he actually said.
Were you surprised by the attention, the extent of it?
I probably shouldn't have been surprised. High-profile lawyer, death of a wife, death of a child, accusations of stealing millions of dollars from clients, allegations of a lawyer hooked on drugs. It had all the ingredients for something of major public interest.
Were you surprised at all by the speed with which the jury came back with the verdict?
I wasn't. My experience in recent years is that jurors don't take a long time deliberating after they've spent weeks and weeks and weeks listening to testimony and receiving evidence.
Last March, Judge Newman sentenced Murdaugh to 2 life sentences while declaring he'd be forced to live with what he'd done.
Within your own soul, you have to deal with that. And I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you.
Pretty powerful.
Yeah.
You think that he'll be haunted by his wife and son?
No, I think so. It has to be. I cannot imagine him having a peaceful night knowing what he did. I'm sure if he had an opportunity to do it over again, he'd never do it.
Judge Clifton Newman plans to retire this fall. As his legal career comes to a close, he reflected on Murdaugh and his most high-profile case.
Felt sorry for him, felt that that he was just in a position where he could not, where if there's a hole that he could go into, he would dive in that hole and keep going to the lowest depths. And I wasn't trying to pull him out of that hole, but I wanted to give him an opportunity to say something.
Alec Murdaugh still maintains he did not kill his wife and son. There were certain questions that Judge Newman declined to answer because this is a case that is being appealed.
He was asked about his statement that he made during the sentencing hearing, saying Paul and Maggie come to visit Alex in his sleep, and whether he thinks Alex is in fact haunted by his wife and son. His answer gives Alex more credit than Alex deserves, in my opinion. Yes, Alex is awaiting an appeal, but right now, he is legally guilty. Judge Newman is not blasting his guilt or saying his appeal will never work or shouldn't work. He's simply answering a question about a statement that he made after a guilty verdict was read in his courtroom, which I could see as being considered in compliance with the canon that says this section does not prohibit judges from making public statements in the course of their official duties, which he was doing when he made that statement at sentencing, or from explaining for public information the procedures of the court. But we'll leave it to the Supreme Court to sort that out. Next, they move on to these accusations against Becky Hill. It's everything we've heard before. My only comment to that, because we've talked about it so many times, is that we can't really say anything to that with certainty because it hasn't been proven. They continue to say that she fabricated a Facebook post with zero evidence that she did so. And the claim that she wanted this juror removed because she thought she might not vote guilty, something she couldn't have possibly known at the time. And then they mention that she was in fact removed from the jury for a different reason. That reason had nothing to do with these Facebook posts. She was removed for a legitimate reason. She was out there running her mouth, plain and simple. They again keep mentioning other supposed claims that haven't been proved, so I'm not even going to comment on those. But this one claim, they say that she said if they deliberated past 11, they would be taken directly to a hotel, even though none were prepared to stay overnight. Wasn't it her duty to tell them this as clerk of court? If that's what was going to happen, they needed to know, and they needed to know as soon as possible. She didn't make this up. She didn't have the power to say that. And wouldn't it be best to be sequestered during their deliberations of such an important trial? Wouldn't the court not want to risk any undue influence? They were actually very lucky not to have been sequestered the whole time for such a big trial. It's a clerk's duty to have given them this information. The rest of the accusations have not been proven, so I'll skip those two just for the sake of time. Then they bring up that tiresome rag of a document, the motion for a new trial, and mention the supporting affidavits again, forgetting to admit that 2 of the 4 so-called affidavits were prepared and signed by Holly Miller, and that only one of those two actual affidavits was signed by a juror who was actually there for deliberations. They then mention that Judge Newman is assigned to decide that motion. Well, yes, this is typical court arrangement for the original judge to hear the appeal. He's familiar with the case, he's familiar with the evidence, he's familiar with whether or not information is new and or relevant for a new trial. Nothing is wrong here. This is typically how it's done. They next try to give legal reason for exercising this writ of prohibition on the next 2 pages, and they use Rule E1B as their reasoning, which states, it's under disqualification, and it says that a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including, but not limited to instances where, and the one they cited was B, the judge served as a lawyer in the matter in controversy, or a lawyer with whom the judge previously practiced law, served during such association as a lawyer concerning the matter, or the judge has been a material witness concerning it. So they're calling the judge a material witness. This is a stretch. And here's their reasoning. They say this Code of Judicial Conduct requires that he disqualify himself because the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. So their claim is that he has personal knowledge. The judge does not have personal knowledge of these claims. He has knowledge that she's been accused of these things, but no actual personal knowledge if she actually did them or not. The rule of the code that they used mentioned being a material witness. What is a material witness? It's someone who has important information about a case that can help decide who is right or wrong. In the last sentence, this is because their testimony is very important and cannot be replaced by anyone else. And in this more thorough explanation, it says it's someone who has important information that can affect its outcome. This information is usually very valuable and not many other people have it. What information does Judge Newman have about this that other people do not have? It gives an example of a witness who saw a crime happen and can provide important details that no one else knows. This witness would be considered a material witness because their testimony is crucial to the case. The judge presided over a hearing that all counsel was present for, in which they questioned the egg juror about a Facebook post. Judge Newman did not hold this hearing in private chambers. He does not have more information than anyone else that was present at that hearing. This was an in-camera hearing. He did not see or hear anything more than what that entire group heard and saw, including counsel. So if Judge Newman is a material witness and thus cannot preside, then counsel is as well and cannot serve as counsel by this logic. Judge Newman does not have any additional information about this Facebook post than what anyone there has. He's not a material witness. He has no idea who posted it or whether it can be traced to Becky Hill. This is a stretch. They claim that something said in camera showed that they had multiple conversations about it. But what does it actually say? This is their claim here. Statements made by Judge Newman during an in-camera hearing involving juror 785, which is the egg juror, indicate that Judge Newman and his law clerk had multiple conversations about juror 785 with the clerk of court that are not reflected on the record. But what does it say? It says she had indicated that she read a Facebook post over the weekend referencing this. This is Friday, and she just mentioned it today. Where in the transcript does it say anything about multiple conversations that Judge Newman had that are not reflected on the record? He says she just mentioned it. And what did he do? Immediately called for a hearing with all the parties. There is nothing that says they had multiple conversations off record. An initial notification of the judge is necessary before a hearing is called, and that's exactly what he did. This was a hearing involving the same people. They all have the same knowledge. If one of them is a material witness, so they all must be. And guess what? South Carolina has rules on that too. Rules about lawyers being material witnesses. They were there, heard everything Judge Newman said. If what he heard made him a material witness, it made them one as well. So, are you going to step aside too, Dick and Jim? By your definition, you're material witnesses too. Then they have this bizarre Exhibit E with no explanation as to why it's here. It's an affidavit by a Dr. Gregory B. Adams, a professor of law at the University of South Carolina School of Law. He somehow felt it necessary to write a statement of his opinion, not something asked for by the court, and include his 10-page CV full of publications, honors, education, and work history, which includes only 4 years of law practice and the rest teaching. It's hard to imagine what behooved him to pipe up for this, but what an interesting little twist. And look at how I'm talking after reading his affidavit. I never say words like behoove or expressions like pipe up, and here I am. That's the effect this haughty little paper no one asked for had on me. He's probably an old friend of Alex's father and grandfather, or Dick himself, but basically he says in his expert opinion that no one asked for that Judge Newman must recuse himself. He also states as fact the accusations made against Becky Hill that have not been proven. That right there is enough for me to disregard everything else he says. What's the old proverb about speaking on a matter before it's been heard making one a fool? His affidavit is entirely everything Dick says in this writ, except for the last 2 1/4 pages are him blowing his own horn, though, as mentioned, he includes his 10-page CV, so really wasn't necessary to also put 2 1/4 pages of his accomplishments in the affidavit itself. His signature alone spells grandiose to me, and I really have no idea why this is included in here, and that's all the attention I'm going to give this attention seeker. Their claim on page 10 is unfounded as well, where it says a clerk of court is accused of bringing fabricated evidence to the judge in an attempt to influence the jury's verdict to achieve personal fame and money in a high publicity case. As I said in my last podcast, influencing the jury was not necessary for her to gain publicity or for her to write a book. In fact, a not guilty plea would have been even more controversial and brought more people to want to know what went on behind closed doors to lead the jury to such a mistaken verdict as not guilty. Was she looking for fame and money? Obviously. But she didn't require a guilty verdict to do that and could have had more with the not guilty verdict. So this is a silly point to try to make, and especially to just say it out like it's fact. And then it goes on again to say more about Judge Newman being called to testify. And it says no one would question the need for a judge to recuse himself from presiding over the prosecution of a crime he personally witnessed, even if there were many other witnesses and the crime were caught on video so that his testimony would be unnecessary. So now he's personally witnessed her crime. No one has proven that Becky created that Facebook post in the first place, and Judge Newman is not a witness to that crime, even if they can prove that she did create this Facebook post. To say he's a witness to the crime would mean that he sat there and watched her do it. We don't even know whether or not this crime exists, let alone start naming people as witnesses to the crime. It's easily proven by forensically checking her devices to see if she did. But even then, Judge Newman, unless he sat and watched her do so, is not a material witness to that crime. Then they have this ridiculous footnote. Miss Hill certainly will be a witness, and she will be asked about bringing the Facebook issue to the attention of Judge Newman. If she testifies falsely about that, Judge Newman might know it. If that happens, what then? Everyone knows she brought the Facebook issue to his attention. It's a matter of public record. He said so in the hearing. Judge Newman is not the only one who would know if she testified falsely. So would all of counsel who were in that hearing. And then insinuating that this would affect his ability to preside over the case. What an accusation to make. These are allegations of criminal behavior they're charging him with, and it's completely unfounded. And they're making such a big deal about what he said to the jury about their conclusion. Have you ever sent a text and had your words misunderstood because the receiver didn't know the tone of your voice, since it was just words on a screen? I think most of us have been on either end of this, when we take something wrong or we are taken wrong. When we read these words on a page, they sound shocking indeed. But just for fun, let's listen to what he said to the jury in full, catching tones, pauses, facial expressions, and fully understand what he was saying to them. Is that fair?
Madam Foley and members of the jury, I want to thank you on behalf of the citizens of the state of South Carolina and your fellow citizens of Colleton County. You did not volunteer for this service. You were called upon by being summoned to appear, and Providence have brought you to this moment in time and these weeks in time. I know that all of you have been here at great sacrifice, particularly the juror whose job was on the line until a miracle happened, I guess, that allowed him to be able to leave rather than leave after 2 or 3 weeks. But I want to thank each one of you all individually and collectively. It's not often that you're called upon to sit in judgment of the actions of your fellow man, but you all responded and gave due consideration to the evidence. I will make no comment now as to the extent or the overwhelming nature of the evidence.
He said the overwhelming nature of the evidence. Do you remember how much evidence was in that courtroom? When I toured that courthouse, I saw the room where all the evidence had to be stored. It was a whole holding cell. I saw the cart that it took to wheel that stuff out. It was huge. Do you recall the days of evidence being read off and accepted by the court? It took hours and hours of days. Is that not overwhelming? Is that not what he meant? In addition to those physical bits of evidence, there were hours and hours of video played, dash cam videos, body cam videos, interview videos. Was that not overwhelming? Was that not what he meant? There were multiple experts and so-called experts giving testimony about shooting angles and wounds and blood and brains. These people had to see photos, the likes of which they'd never seen and probably hope to never see again. Was that not overwhelming? Was that not what he meant? They had to sit for a couple of days and listen to Alex and watch the snot roll down his face. Was that not overwhelming? Was that not what he meant? I'll play it again, but to me, it is abundantly clear that Judge Newman is talking about the sheer volume and horror of the evidence they had to take in.
It gave due consideration to the evidence. I will make no comment now as to the extent or the overwhelming nature of the evidence.
Again, the overwhelming nature of the evidence. It's clear as can be. This next bit is a little harder to define for sure. I've seen comments that say by this he could simply mean it wasn't a hung jury, it was a unanimous verdict, it didn't have to be a mistrial. Personally, I don't want to guess at his meaning.
But certainly the verdict that you've reached is supported by the evidence, circumstantial evidence, direct evidence, all of the evidence pointed to only one conclusion. That's the conclusion that you all reached. So I applaud you all for, as a group and as a unit and individually, evaluating the evidence and coming to a proper conclusion as you saw the law, as you saw the facts.
I think Judge Newman has a right to be able to give an explanation as to what he meant. But in the end of speaking this, he does clarify, as you saw it, as you saw the law, as you saw the facts. So proper in their eyes, the jury's eyes, the deciding people's eyes. It was proper in their eyes. This clarification, I believe, saves him. But again, he and no one else has a right to be heard and a chance to explain exactly what he meant here. Not to just leave it to Dick and Jim to speak for him, as they so clearly have misinterpreted so many things here. Judge Newman is unblemished in his career. He doesn't need people to be jumping to conclusions about his meaning. He deserves the right, and he alone, to clarify his meaning in this statement, and I will leave it at that. Then they quote a case from New Jersey law, which has no relevance here since each state has its own canon to follow and their law may read differently than South Carolina's law. Then they state, Judge Newman was placing into the record his opinion that if his decision to allow weeks of testimony on financial crimes unrelated to the murders, there they go again, it was motive, it was related, which he admits was pretty controversial, is error, it should not result in a new trial. Likewise, in his opinion, any issues raised in post-conviction review proceedings should not result in a new trial. Judge Newman broke a binding rule of conduct to opine on the record that any errors discovered in the trial proceedings, whether on direct appeal or collateral review, should not result in a new trial. Now they're just leaving the word nature out on purpose here, because it really changes the meaning of this sentence. If you say the overwhelming evidence, yes, it means what they're implying here, but that's not what he said. He said the overwhelming nature of the evidence. That means there were aspects of the evidence that were overwhelming. They're leaving this word out on purpose to mislead. This is not what he said. Then the accusations get even uglier, claiming personal offense and bias. They say, but Judge Newman's comments at sentencing show personal bias regarding Mr. Murdaugh and his family that is well beyond the general attitudes common to the public generally about murder. Judge Newman's comments take personal offense that Mr. Murdaugh denied he committed the murders, which is Mr. Murdaugh's legal right. Again, let me say, have they never attended a trial before? Are they not aware that part of sentencing hearings are the judge's remarks, and they state such things on a regular basis as an explanation for the sentencing they choose? I played the examples of Chris Watts and Lori Vallow's sentencing hearings as examples of such. This is judicial bias, not personal bias. This is another stretch. And then they post some of the things that he said at the time. And you've engaged in such duplicitous conduct here in the courtroom. He had mentioned his statement of alibi, something he submitted to the court in November, long before the trial, to supposedly prove his alibi. His alibi that stated that he wasn't at the kennels. Then on the witness stand, he admitted that he was. This is duplicitous conduct.
Oh, what tangle web we weave. What did you mean by that?
Meant when I lied, I continue to lie.
And then they have to admit that Alex did deflect in his lies about the kennels and the assisted suicide, where they say Mr. Murdaugh did lie about being at the kennels shortly before the murders, which could be called a deflection of the investigation. Mr. Murdaugh also briefly lied about his attempted assisted suicide attempt. But notice that little parentheses after saying that he lied about the kennels. Albeit a very ineffectual one. How are they calling that lie ineffectual? It only became ineffectual because of Paul's video that proved it was a lie. Had that video not existed or not been found, it would and could have never been discovered that Alex was actually at the scene of the murder. How is that an ineffectual lie? In fact, jurors have said that the kennel video proving he was lying was the biggest reason they found Alex guilty. How are they going to claim that this little deflection was a very ineffectual one? Come on. That's ridiculous. The suicide attempt lie was ridiculous too. Then this is the supposed proof that his Wheels of Justice comment meant Alex's family.
In this case, qualifies under our death penalty statute. based on the statutory aggravating circumstances of two or more people being murdered by the defendant by one act or pursuant to one scheme or course of conduct. I don't question at all the decision of the state not to pursue the death penalty. But as I sit here in this courtroom and look around the many portraits of judges and other court officials and reflect on the fact that over the past century, your family, including you, have been prosecuting people here in this courtroom, and many have received the death penalty, probably for lesser conduct.
What kind of stretch is that? It refers to Mr. Murdaugh's family as a symbol of corruption in the Low Country? What was said about corruption? Nothing. This is such a stretch. This man is going to need some Icy Hot, some Bengay, some Aspercreme, some Tiger Balm. What else do I see here? Badger Sore Muscle Rub. He's going to need all the muscle rubs for this stretch. But then Judge Newman goes on to talk not just about Alex, but about his family. And it's fondness. It's genuine, sincere fondness. He doesn't speak ill of any of them. He truly seems saddened to see what Alex has become. This is not what they're trying to make it out to be. Like he's finally getting a chance to get at the corrupt family in the Low Country. This is so wrong.
A lawyer, a person from a respected family who has controlled justice in this community for over a century, a person whose grandfather's portrait hang at the back of the courthouse that I had to have ordered removed in order to ensure that a fair trial was had by both the state and the defense. It's also particularly troubling, Mr. Murdaugh, because as a member of the legal community and a well-known member of the legal community, you've practiced law before me, and we've seen each other at various occasions throughout the years. And it was especially heartbreaking for me to see you go in the media from being a grieving father who lost a wife and a son to being the person indicted and convicted of killing them. I don't know person who's always been such a gregarious, friendly person can cause your life to be tangled in such a web, such a situation that yours have spun into, and it's so unfortunate because you had such a lovely family of such friendly people, including you, and to go from that to this.
It's obviously that he's moved on to a different topic completely, and he mentions not just Alex's family, but the portraits of judges and other court officials to which Alex and his family were a small part of. He says it because it is more shocking when a lawyer commits an illegal act, and there's nothing wrong with stating that. It's very shocking indeed that his great-grandfather Randolph Sr. went after many fraudulent bankers and their accomplices and gave them big sentences. I remarked on that in one of my earlier podcasts because of the irony. Judge Newman was not wrong to mention it. And again, how does mentioning his family show personal bias? It's a simple observation of the facts of this case. And how in the world do they leap to the conclusion that Judge Newman said the death penalty would be desirable in this case? He said it qualifies, and he gives the legal standard. He says, and this case qualifies under our death penalty statute, based on the statutory aggravating circumstances of 2 or more people being murdered by the defendant by one act, or pursuant to one scheme or course of conduct, and many have received the death penalty, probably for lesser conduct. He says it qualifies, and he gave the legal standard. He even states he doesn't question the state's decision not to pursue the death penalty. He doesn't say it's desirable or express any disappointment that it was not issued. He simply states that it qualifies for, which is judicially correct and not evidence of any kind of bias judicially or personally. Apparently, the defense team are now mind readers by all of these accusations. Then they say, Judge Newman's comment that law enforcement has been maligned for the past 5 or 6 weeks is further evidence of personal bias against Mr. Murdaugh and against his counsel. Defense lawyers have a duty to challenge the quality of the investigation that generates evidence against their clients. Yes, defense lawyers have a duty to challenge the quality of investigation, but let's think about ways they were unfairly maligned. For example, Alex saying he lied because of the way he was being treated, the way he was being questioned, and because of who he thought the officer that was questioning him was. We saw body cam video and dash cam video. Alex was absolutely not being treated as he described, and it was later shown how there's no way he thought he was talking to the officer he lyingly claimed he thought he was talking to. Those were not mistakes made by police officers. Those were instances of Alex trying to lie his way through explanations for his previous lies. And he didn't mind that his lies were unfairly putting law enforcement in a bad light, when in fact, those accusations were completely unfounded. If they had not had body and dash cams, this testimony could have been unfairly believed. And though defense has a right to defend their client, let's not pretend law enforcement was not maligned in order to do that. No one on any of those body cams or dash cams was mistreating Alex. They gave him way too much credit. Had they been suspecting him, they might have been able to find better evidence. I've already shown from the code that educating the public on the legal process is not against the rules of the code. But since they often talk in circles in their filings, we have to answer in circles. Judge Newman did nothing wrong speaking at a law school in a scholarly presentation or on the Today Show of explaining procedures of the court for public information, during which he showed more kindness to Alex than he deserved if you read the transcript or saw the show. They state again, Judge Newman even went on a major national broadcast, the Today Show, to proclaim Mr. Murdaugh's guilt before Mr. Murdaugh's direct appeal was even briefed and before he had a chance to move for a new trial. Oh, kind of like how they did a press conference and have gone about slandering Becky Hill, proclaiming her guilt before her guilt has been proven. And this document makes it all sound so much worse than when you read the actual transcripts and find out it's not at all like they're making it out to be. For example, this Cleveland State University College of Law is 53 pages. Only 17 mention the Murdaugh trial at all, and most of those are very light mentions by other people. They're not even directly talking about Alex in most of those. He says very little himself about the trial and even less about Alex. That's why they have to keep repeating the same lines over and over in this document. I'll link the video because I personally loved it. We get a chance to hear a lot more about Judge Newman's remarkable life, from attending a segregated school to his law education, his family, the loss of his son, other cases he's heard. It's a really nice interview with very little mention of Alex. And the things he says about Alex are far too kind in my opinion. On the Today Show, he said even less, and he showed so much much compassion for Alex, more compassion than Alex deserved, because he never showed compassion. Not to his clients, not to his family. He left victims everywhere. They mention these remarks. He's asked during this interview at the law school in Cleveland, do you think that he'll be haunted by his wife and his son because of the statements that Judge Newman said at the sentencing hearing? He said, oh, I think so. It has to be. I cannot imagine him having a peaceful night knowing what he did. And then he says, I'm sure if he had an opportunity to do it over again, he'd never do it. Alex was found guilty of killing his wife and son. Judge Newman made this remark at sentencing, and he was asked about it. He explained the meaning behind his words that were said during a court proceeding. He's explaining that court proceeding in an educational setting. He also gives Alex the benefit of the doubt that he doesn't deserve. He also says, I felt sorry for him, meaning Alex. I felt that he was just in a position where he could not, where there's a hole that he could go into and dive in the hole and keep going to the lowest depths. And I wasn't trying to pull him out of the hole, but I wanted to give him an opportunity to say something. And the host goes on to say, Alex Murdaugh still maintains he did not kill his wife and son. There were certain questions that Judge Newman declined to answer because this is a case that is being appealed. Judge Newman expresses compassion again. Undeserved compassion, giving Alex the benefit of the doubt and explaining the court proceeding again. Judge Newman has made the host aware, and he makes viewers aware that there are things that can't be discussed. It was not some free-for-all witch hunt on Alex. The rest of the interview is talking with Judge Newman's daughter and discussing other things in his life, such as the loss of his son shortly before trial. No smoking gun at all. In the document, they now circle back to the Cleveland Law School presentation again. But again, the code allows for conversations that explain the procedures of the court, and the code for federal judges specifically allows for scholarly presentations. They'll be hard-pressed to get a Supreme Court judge to rule against Judge Newman for this, in my opinion. This is a long document, so for the sake of time, I'll wind things up here. The filing goes on in circles again, mentioning the same few statements Judge Newman made, because that's literally all they have. They accuse him of personal bias once again and state again that Judge Newman is required to disqualify himself, and therefore Alex had no effective legal remedy other than to file this extraordinary writ. And then, after all these accusations, they put this sentence in. Mr. Murdaugh recognizes that Judge Newman is a distinguished and honorable jurist of outstanding character. Laughable. Then why did you just slander him in 25 pages? And then they conclude with this. For the foregoing reasons, petitioner respectfully requests the court to issue a writ of prohibition in its original jurisdiction, prohibiting the Honorable Clifton Newman, Circuit Court Judge, from adjudicating petitioner's motion for a new trial or presiding over future trials of indictments against petitioner. I am eagerly awaiting a reply to these accusations. The state will no doubt have a reply, I'm guessing from the Attorney General's office, before a response from the Supreme Court. And as always, I will share any new developments with you here. I'd love to hear what you all think of this in comments. And I just love reading all of your comments. You all make it so nice to be here, so keep those coming, please. This is Cassidy O'Connell saying stay well and stay tuned.